Let me address a first word of affection and thanks to the general coordinator of the project, dear Professor Dragitsa, and to the other members of this consortium from the universities of Belgrade, Örebro, Lumsa, and Sarlan, who once again continue collaborating in the implementation of our project. On this second day, I would like to welcome my colleagues of the organization committee, in particular, Professor Isabel Ribes, and all of you who are following this event online. There is no doubt that new technologies allow us to be close when we are thousands of kilometers away, and for that I am glad. However, I regret that this time the Congress was not held in the traditional way, which would have allowed all of you to get to know and enjoy such a wonderful place as Cádiz. I hope that next time it will be possible. As it has been highlighted here, the Lawgem project aims to contribute to educate students of law in a gender-sensitive manner, leaving a mark of future generations of legislators, judges, prosecutors, and all types of legal professionals in all areas of legal practice. On this occasion, we are going to address the gender perspective in practice with the support of our next speaker, Dr. Julianne Kokott. She's an extraordinary woman with a strong legal background and an impressive professional career. She's doctor in law from the Universities of Heidelberg and Harvard, and has been professor of international law and European law at various universities such as Augsburg, Heidelberg, Düsseldorf, or St. Gallen. She has held positions of responsibility like deputy judge for the federal government at the Court of Conciliation and Arbitration of the Organization for Security and Cooperation in Europe, among others, and she's author of several publications, some of them related to gender issues. Above all, I would like to point out that since October 2003, she has been an advocate general at the Court of Justice of the European Union, where she has been involved in cases related to gender and law, obviously. Given her professionalism and experience, today we will have the privilege of listening to her with the intervention entitled Impact of Gender Perspective on Legal Profession. Dear Mrs. Kokott, sorry, the floor is yours.
Dear students, dear colleagues, ladies and gentlemen, it's a pleasure for me to speak to you today, thereby contributing to this very interesting conference on a topic that, as you can easily imagine, is very close to my heart. I fully support the project to set up a master study program in law and gender within a framework of collaborating universities. As a coincidence, I noted two things. First, one of the entities participating in this program is the University of my homeland in Germany, the Saarland. And second, one of my home universities, the Washington College of Law, offers more gender law courses than any other law school in the world, but maybe your program one day might become even bigger. In such programs, you learn fighting employment discrimination, preventing domestic violence, ending human trafficking and forced labor, or ensuring economic equality and reproductive rights. The subject on which I was asked to intervene is impact of gender perspective on legal profession, useful or harmful. And I must confess that when I read this title, my first reaction was to wonder how a gender perspective on legal profession could possibly be harmful. However, when reflecting on this point, it appeared to me that one could understand the question of whether a gender perspective on legal profession could be harmful as aiming to trigger reflections under 2 points of view. First, when checking women's presence in some, not all, but in a sense, the most prestigious sectors of the legal profession, it quickly turns out that they are often significantly underrepresented. At my own court, for example, out of 38 judges and advocates general, only 7 are women, and in our lower tier general court, out of 50 judges, only 16 are women. In other international courts, tribunals, and jurisdictional bodies, the situation is in many cases alike, as I recently discussed during an online conference dedicated to the underrepresentation of women in international justice. In view of this, the need for positive discrimination might seem obvious. Indeed, how to achieve gender equality if not through the instauration of quotas and the like? But then detractors of such kind of measures could argue that this is not fair to male candidates, and more generally, the impression could arise that women promoted via such mechanisms are mere token women whose qualifications compared to those of their male counterparts are doubtful. From this point of view, a gender perspective on the legal profession, might it be harmful? In addition, a gender perspective on legal profession might eventually be harmful from a second point of view. Thus, one could have the idea that for a given case or the interpretation of a given legislative provision, there necessarily is only one right solution, that the law is objective. However, promoters of the accession of more women to judicial profession often argue that those women would make decisions that would be substantially different from those made by their male counterparts. This corresponds to the idea that women in judicial functions could bring an added value, in the sense that they would have another view on legal issues, notably those relating to human and women's rights, and an increased sensibility for those issues as compared to male judges. But does this thesis fit with the idea according to which for every given case there is one legal solution? Or is it so that in reality it's only the confrontation of different perspectives and backgrounds that makes us discover the right legal solution? This would then plead for much diversity, so much diversity on the bench as possible. My reflections on these two issues, the underrepresentation of women in the most prestigious judicial functions on the one hand, and the question of what is the added value of gender equality on such benches on the other hand, constitute the background of my intervention today. This being said, in this intervention, I will focus on 3 points. First, I will shed a glimpse on the current state of underrepresentation of women in many high-profile judicial functions and address the question of how to improve this deplorable situation. Second, I will address the contribution of the European Court of Justice and the EU legislation to gender equality. And finally, third, I will discuss the question of the possible impact of the composition of the bench in terms of gender equality for the outcome of judicial decisions. The current underrepresentation of women in international justice and academia, and how to improve the situation, that's what I now address. as I am an advocate general at the Court of Justice, but also a law professor, the two sectors of legal profession I will mainly refer to in my speech will be the judiciary and academia. As I already mentioned, at my own court, out of 38 judges and advocates general, only 7 are women. It is true that in October of this year, we will have a partial renewal of the court's members, and there will probably be some more new female colleagues nominated then. However, women will still be significantly underrepresented among the judges and advocates general. As far as the lower tier general court is concerned, its situation in terms of gender parity has even been subject to an intervention by the EU legislator, when the EU legislator decided in 2015 to increase the number of judges at the General Court from 38 to 56, which means 2 judges for each member state. It highlighted in the relevant regulation the, quote, high importance of gender balance within the General Court, end quote, and stipulated that each member state should nominate 1 woman and 1 man. However, as of today, out of 50 judges, only 16, meanwhile, since very recently, since last week, only 16 are women. It is true that when I spoke about this issue for the last time in 2016, women judges at the General Court were merely 12 out of 15, instead of 16 now. This shows that the situation is certainly getting better, gradually, but very slowly. If the rhythm does not accelerate, it will take more than 15 years from now to reach gender parity at the sole General Court, let alone the Court of Justice. The composition of the Court of Justice's bench depends mainly on national nomination mechanisms, as judges are nominated by the EU member states. And there the problem is that there are still far more high-profile male lawyers among the possible candidates. For example, in my home country, Germany, judges and advocates general for the Court of Justice are mainly chosen among university professors. However, less than 20% of law professors in Germany are female, notwithstanding the fact that among law students, there are today more women than men. But here again, the situation is improving. When I was nominated a professor of public international law, we were 3 women, imagine 3 women out of 400. 3 out of 400. Now it's somewhat better. Traditionally, women still do not choose the most high professional post in the judicial profession. University professorships, chairs, presidencies of courts and tribunals, etc. They used to stay in lower positions in the judiciary, in the first instance courts and tribunals. This limitation of women is to a great extent also due to the framework conditions for the combination of work and family life. In the first place, the lack of childcare structures and the fact that care work is still mainly done by women. Consequently, if they have a professional career, women have the double charge of working in this professional career and doing most of the family work at home. The maintain of these bad framework conditions and traditional work allocation prevents women from engaging in high-profile judicial and academic careers from the outset. And then, when it comes to nomination procedures for institutions such as the ECJ, they are not there to run for nomination. Yet, unfortunately, the current pandemic has even worsened the work-family balance condition for women, as is impressively documented by the Global Gender Gap Report 2021, issued recently by the World Economic Forum. According to this report, it will statistically take more than 130 135 years to reach gender parity against 95 years, calculated in 2019. This deplorable trend will unfortunately indirectly also affect women's participation in high-profile international judicial positions if there are no measures of positive discrimination taken in order to reach a more gender-equitable composition of these benches. Moreover, as I recently wrote in an editorial published in a German newspaper, it is crucial to encourage young women to combine maternity and a career. Too often, they still think that they have to choose one or the other. This is because, first, the family today in most Western countries provides little or no support to working mothers in our individualized society. And second, a role model of mothers as the only caregivers for small children is promoted by tax incentives to stay at home in Germany, and also tax disincentives for domestic help in many countries. Women judges possibly would have declared such tax measures incompatible with gender equality because they factually disadvantage and discourage women and reinforce stereotypes. As I wrote in my editorial, and as I keep on repeating in my speeches, to encourage the combination of motherhood and career, we need first good and affordable all-day childcare structures, and second, fair wages for people working in the care and nursing sectors, mostly female people. And third, a taxation system that allows to set off costs for childcare and housekeeping against tax liability, and that encourages both partners to work, so-called family splitting. Good framework conditions really make a difference. Take the example of our law clerks at the Court of Justice. We have a generous regime of 5-month paid maternity leave plus, and this is important, the possibility of having a good replacement for the mother at leave. Furthermore, there are very good childcare structures here in Luxembourg. Consequently, most women at the court combine very nice legal careers with having a family. Under the highly qualified legal secretaries of the Court of Justice, we meanwhile have 43% women, 73 out of 170. One could certainly object that these women are in a privileged situation, which is true. Nevertheless, the aim should be to offer this kind of possibilities to combine work and family life to all women. This is also important because the state has an interest in generational change and a high level of employment of women. Last but not least, we need also to empower women, and especially young women and students like you, to be confident about their potential and opportunities. This is important to prevent women from auto-limiting themselves, which often starts at a very young age. One example of empowering girls is an initiative by the Luxembourgish Minister for Gender Equality. The minister distributes books in the nursery who tell stories in which mom is the mayor and dad on parental leave, and where the little girl likes to drive go-karts and repair cars and the little boy likes sewing. The fact that the latter kind of books needs to be produced on command and sponsored by the Ministry for Gender Equality shows that this kind of narrative is still not part of normality yet, and that their production amounts to a kind of positive discrimination. But this example also shows that positive discrimination is important because it helps building new role models for girls and helps breaking up traditional role models that still prevent too many women from reaching the top today. It is important to work on people's mindset, to change mentalities, to create new role models. This is why I also engage in a mentoring program and try to encourage women with my own example and accept home stories in the newspapers. But often it takes a lot of time to change mindsets and mentalities. This is why the legal conditions of women in a society are so essential for their empowerment. This brings me to my second topic today, the promotion of women's rights by the European Court of Justice and the European legislator. The status of women is intimately linked to the legal framework that a society has established for itself. None of the important progresses that have been made over the past decades and centuries in the area of equal treatment would be conceivable without concrete legal provisions and case law implementing. Take the example of women's right to vote in national elections, which was introduced by many European states in the first half of the last century. The achievement of this right was preceded by a long struggle of the women's movement, which started in the 18th century. Sometimes legal rules on the status of women merely mark the end of an evolution in society that has been going on for decades. For example, there was a time when women needed the agreement of a man, usually their husband or father, to choose their place of residence, and it's still so in some parts of the world, to enter into an employment contract and even to open a bank account. When this anachronism was finally abolished, this was only the logical consequence of a more modern way of thinking that had gradually taken hold in people's minds. The same is true for the legislation on divorce. However, there is also the opposite situation in which a proactive policy takes the lead in order to favor the adoption of legislation on the status of women, which subsequently proves to be an initial ignition that ultimately changes our society and the role that women play in it. It is precisely in this last category that I would place most of the rules on the status of women that originate at the European level. In this regard, the principle of equal treatment between women and men has always been one of the founding principles of the European construction. Its concrete implementation began with the insertion of a provision in the Treaty of Rome establishing the principle of equal pay for male and female workers for equal work or work of equal value. In the 1950s, this was particularly progressive and did not correspond at all to the societal and economic reality. But France pursued a politique de natalité. They wanted to encourage women to have children, and that's the reason whether they had such rules in the domestic law, and France feared competitive disadvantages for its industry if France would be the only country which protected women and mothers. Therefore, the initiative to introduce equal pay for equal work, including for equal value, that's important, was motivated, at least initially, by economic rather than by social considerations. However, one can assume that the development of the status of women in many member states, including in my home country, Germany, has been greatly accelerated by the establishment of the principle of equal pay at the European level. Thanks to this rule, the so-called gender pay gap has been reduced over the years, even if it has not yet been possible to close it completely in all sectors. In the 1970s, the Court of Justice took the opportunity to emphasize the dual purpose of this principle of equal pay, now enshrined in Article 157 of the TFEU. It ruled that gender equality is also a principle of social law that must be implemented not only through legislation, but also through case law. Thus, in the context of three famous rulings bearing the name of Mrs. Defresne, a stewardess of the former airline company Sabena, the court established, among other things, the direct effect of the principle of equal remuneration. Through its jurisprudence, the ECJ has contributed to making this rule a key element of European social law. Among the most recent legislative works, it is important to mention the so-called Anti-Discrimination Directive of 2004, which extends the principle of equal treatment beyond the classical field of work to prohibit discrimination also in access to goods and services, such as insurance contracts. Against this background, the court issued the famous Test Achat ruling in 2011, which resulted in an end to the unfortunate practice of insurance companies applying unequal insurance premiums according to the gender of policyholders. The Test Achat decision is thus, in a sense, the origin of the so-called unisex rates you are offered today when you insure your vehicle or obtain supplemental health insurance or purchase life insurance. Women were discriminated particularly in the field of health and life insurance. It is interesting, however, to note that the founding stones of this highly protective jurisprudence for women came from a court that was, for many years, composed exclusively of men. This is a good example that shows that you don't necessarily have to be a woman, let alone a feminist, to advance the equality of treatment between men and women. And that brings me to my third and last point of my speech today, the question of whether women judges do make a difference in terms of substantive output of judicial decisions. Even if the jurisprudence of the ECJ court, of the Court of Justice, I just outlined, provides some encouraging examples, otherwise, I remain convinced that women do make a difference and that gender balance in all courts is a must in order to have courts which are able to see the full picture and all sides and facets of conflicts of interest in the society. Diversity in the bench is very important, and this should also play a role in judges' nomination processes. In my land, in Germany, we have a system that just takes the persons who have the best law degrees. Other factors such as experience or personality are not important. I think that this is wrong, even though women have excellent exams. I have made many judgments, I have read, not made, I have read many judgments which are full of stereotypes about women, which would certainly not have been handed down that way with women on the bench. A very early example of such a judgment is the US Supreme Court's judgment of 1872 that states that the natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life, including that of an attorney. I also doubt whether women judges would understand the German Federal Constitutional Court's reasoning in an order of 2017 that, in granting a tax reduction for domestic help expenses, mothers who take care of their own children's education might feel disadvantaged. Conversely, only a few years later, in 1991, the same chamber of the court whose composition composition had nevertheless changed, meanwhile, to comprise 5 men and 1 woman, decided that the rule according to which, in case future spouses didn't agree on their married name, the name of the husband automatically prevailed was contrary to the constitutional principle of gender equality. When comparing these 2 judgments, one really gets the impression that the presence of even 1 single woman on the bench made a real difference. Maybe together with some societal and ideological progress that had meanwhile taken place as regards gender equality. But the presence of women on the benches of international judicial bodies is not only important for the concrete outcome of single judicial decisions, but also for the overall legitimacy of these decisions. In a recent judgment of the European Court of Human Rights concerning quotas for women candidates in elections, the court not only noted that the promotion of gender equality is one of the main objectives of society today, moreover, it considered that a pronounced imbalance between men and women in politics could jeopardize the very legitimacy of democracy. The same is true for judicial entities such as courts, tribunals, or other jurisdictional bodies. The principle of gender equality is therefore not only an instrument to promote the rights of individuals. Today, gender equality has a societal dimension. At the level of the European Union, this is perfectly illustrated by the reference to this principle found in cross-cutting provisions. This brings me to the end of this speech. Overall, I conclude that the gender perspective on judicial profession in all parts of the world is useful, and that it would, on the contrary, be harmful to refrain from examining legal and judicial questions from such a perspective. This is why I'm delighted that the universities taking part in the Lawgem program have set up this master study program, and I wish you a lot of success in implementing this program. Thank you. Gracias.
Okay, thank you very much, Professor Kokott, or Dr. Kokott, for your enlightening lecture on gender perspective in legal profession. Now we open a Q&A debate. So if you have any question to Dr. Kokott, please raise your hand. Okay, Marco Ebola has raised the hand first. So Marco, please, you have the floor.
Okay, good morning, Marco Evola, Lunza University, Palermo. I want to raise 2 points. The first concerns underrepresentation of women on benches. International courts are often marked by a strict connection between the political power and the appointment of judges. Don't you think that the underrepresentation of women in international courts is related to the underrepresentation of women in politics? Because there is not this connection, since, as I said before, appointment is politically biased. The second point I want to raise concerns the role of women in courts. I don't think that female judges face 2 challenges. The first is to apply a law which is often a gender law, biased by male stereotypes and prejudices. And the second challenge stems from the low number of female judges. Once they enter the courts, they have to accept the male reasoning, the way in which male judges apply laws. And so don't you think that improving the number of women judges is good, but maybe we need not only female judges, but also feminist judges that could reshape the way in which the law is assessed and applied? Thank you.
Yes, politics influence the nomination of judges to international courts, I think that it is very useful if the Minister of Justice is female, because often they are more open and they possibly make a special effort. And regarding my own example, when I was nominated to the Court of Justice, I was a law professor in Switzerland, and I somehow was happy that Germany had not forgotten me because I was not in Germany. And I'm not very sure whether a male Minister of Justice would have made the same effort to look around whether there are qualified women. Yeah, that's one thing. And then adopt to male reasoning. I think that women, independently whether they are feminists or not, they have a different view on certain societal constellations. And I think, also I think the term of feminist is, so I'm not completely sure about its definition. For example, I'm not 100% sure whether I'm a feminist. Probably yes. What is a feminist? I think a person who is for equal rights, completely equal rights, not only de jure but also de facto, and in principle, who could be against that? Yeah. But let me quote my former teacher, Judge Bürgenthal, who was at the Inter-American Court of Justice. And at that time, the Inter-American Commission on Human Rights and the Inter-American Court of Justice were composed exclusively of men. And Judge Bürgenthal also told to me, Julia, if there were only one woman, it would make such a difference. The whole atmosphere of discussion is changed if there is one woman, because maybe men don't speak in the same way. And he was so happy when the first woman, Sonia Picada, I think was her name, and she was nominated. And I recently had this other event on women in international courts, and I was very pleased to be together with with a member, possibly president of the Inter-American Commission of Human Rights. I think it's almost exclusively composed of women now. So we are making some progress. And I think in Western societies, women's life is relatively okay when compared to some other parts of the world. And I would find it very interesting if in your program you do not forget Africa and Arab countries and all the other countries where the conditions are even more problematic than here. Yeah.
Okay, thank you very much. And now, Eleanor Christopherson, please.
Yes, hello. Hello. I would just like to ask you, Julianne Kokott, or first of all, I would like to thank you for a very interesting presentation. But I would like to ask you, because we have what we see in the Nordic countries. I'm from Sweden, and I have also discussed this with colleagues from Estonia, and that is that girls tend to get higher grades in school, and they get higher grades also in law school. And in our countries, the judges are selected based almost exclusively on grades. And that has really changed the picture in our countries. So when I teach judges, I do that quite often in tax law, then I maybe there are one or two young male judges, but the most judges are female in our countries. And my reflection is that it's actually very interesting from a gender perspective that most criminals are men, and most judges are definitely women, at least in Sweden and also in Estonia. I think that development is because you were talking about the other way around when most judges are men, but we see something completely different. And would you see that problematic, or would we, when we get mostly women, mostly or almost exclusively female women, as we see in Sweden?
Yeah. A very interesting question. As to female judges, 100% female judges, in Germany we have, I think, somehow similar development, because yeah, and I would summarize it as a law instance judge is a new teacher, because in former times girls wanted to become school teachers, because then they would only work, they thought that would be perfectly compatible with having a family. And I had many girlfriends at school who were already at the age of 15 auto-limiting themselves and wanting to become teacher, yeah? And even girls with the best grades who could have done something else. And when I did my law exam, the classes were full of girls who really wanted to have those good grades to become a judge and then to combine family life and a career. And I think that this is not a good selection process to become a judge, because that's a secondary motive. Those people do not want to become judges because they are fascinated by justice, because they are really interested in the job, but they are interested in having something to combine with. And insofar, I think it's problematic if all low instance judges are female and if there are no males. And I think it's also for the acceptance of, yeah, it's the legitimacy. Yeah, I prefer to have it, to have mixed judges. And we have the same, by the way, we have the same phenomenon at kindergarten and at school. Teachers who teach skilled women at Volksschule, that means up to age of 10, I think they are 95% female. And this is not good at all, because women and men are a little bit different. The young boys are, I think they are just wilder, but then they are in this all-female environment, the wild boys are somehow discriminated. They think they are supposed to sit and do something with their hands, which is difficult for the boys, and if they don't do it, they are antisocial or whatever. And I think it's even discussed by some psychologists in Switzerland and Germany, das Jungenproblem, the boys' problem. Yeah. And I'm the mother of 4 boys, and I can confirm that it's in some kindergartens, it's difficult. Yeah, it's really difficult.
Interesting. Thank you.
Yeah.
Okay, thank you very much. Is there any question to Dr. Kokott? Oh yes, Dragika, please.
Hello, everybody, and thank you, dear Professor Julianne Kokott, for your very interesting presentation and also the discussion. What I wanted to ask you is your impressions about the state of affair with gender sensitivity and gender sensitization of the judges, either female or male ones in the court of Luxembourg, because female judges also can be unsensitized concerning gender equality. That's first. So are there trends when you take into consideration the discussions on the case law and the decision making, that there are more or less stereotypes and prejudice in those processes of decision making and final decision making? Because you mentioned that you noticed a lot of stereotypes in the judges' decision making. And the second question, there's more and more books published with the title or subtitle Feminist Judgments, in which the reconsideration of the case law from the gender perspective, how it would have been differently decided upon if the gender perspective would have been included. So from that point of view, are there any meetings, or would it be good to have them if there are no of that kind?
I don't hear anymore.
Dragica, you
Sorry,
close your mic.
something happened. I did not touch anything, but the voice was off. So, are there any meetings within the Court of Human Rights of European Union, or between or together between? Because I know that there are some common meetings of the Court from Luxembourg, from Strasbourg, even the German Federal Constitutional Court. So are there any meetings, or should there be, where this gender perspective would be involved in the discussions in favor and for purposes of gender sensitization and better decision making in all of these courts?
I would have to read those interesting books and check whether there are judgments of the Court of Justice and which are somehow criticized, and where I would read that they would have been different if a woman would have participated. I'm really interested whether they identified such judgments. I told you about the German Federal Constitutional Court. I would find some of the German Constitutional Court, surely, of the constitutional courts. Of the Court of Justice, I think it's quite good, and I think it's astonishing. But my explanation is that the Court of Justice started with abolishing the discrimination of foreign workers who in the member states, economic perspective, and then just transferred this discrimination jurisprudence, abolishing any kind of discrimination, including factual discriminations. And from this perspective of eradicating any factual discrimination transferred to gender, the court came out quite well, I think, without even thinking about a gender perspective. I think it's a consequence of how the case law developed. Yeah. And of course, this very good clause, equal pay for equal work and work of equal value. Yeah. And it's interesting, the politique de natalité, France wants more little French babies, yeah, that helped really women in the whole European Union, in all member states of the European Union. And the Court of Justice was far more progressive than our German Federal Constitutional Court. But meanwhile, the Federal Constitutional Court is quasi 50% female. So I think, and including one really feminist who had a feminist chair at the University of the Humboldt University. So I think it's quite okay right now. Yeah. And the German judges at the Court of Strasbourg are also female. So, yeah. But I think it's a lot of work done in some parts of the world. And so your program is really important. And when I had when I found out that American University has so many law professors, specialized law professors, specialized in gender justice, I was really impressed. But I also saw that there are many interesting topics which need to be studied and implemented. Yeah.
Okay, thank you very much. I don't know if there is a final question to Dr. Kokott. No further question? So thank you very much for your inspiring presentation, your inspiring lecture.